Okay, last speaker of the day, the very exciting Howard Nations is here to lecture to us again. He's been at the forefront of civil and personal injury litigation for 45 years. He's built a national practice focused on mass torts, pharmaceuticals, catastrophic injuries, and complex business litigation. He's co-founded and is the current co-chair of the National College of Advocacy and has taught advocacy-related courses in law schools for 35 years. He's a member of the AHA's Leaders Forum. He pioneered the use of forensic psychological and neurolinguistic principles to persuade judges and jurors at trial. He served as president of the National Trial Lawyers, the Texas Trial Lawyers Association, the Southern Trial Lawyers Association, the Belli Society, and the Aletheia Institute, and served for 5 years on AHA's executive committee. He was inducted into the Trial Lawyers Hall of Fame in 2012 and is the recipient of numerous awards, including the W. McKinley Smiley Jr. Lighthouse Award, the Belli Society's Mel Award, AHA's Heavy Lifting Award, and the STOA's Tommy Malone Great American Eagle Award and Warhorse Award. He's a member of the Litigation Council, LLC, and has been listed in Who's Who in America, Who's Who in Finance and Industry, Who's Who in American Law, and Who's Who in the World for 4 consecutive decades. The Nations Law Firm is a national law firm with offices in Houston, Texas, New York City, Washington, D.C., and Atlanta, Georgia. Please welcome the great Howard Nations.
Well, good afternoon. I have one other capacity he didn't mention since we covered everything since birth, but we forgot this one. I also happen to be chair of the National College of Advocacy. And in that capacity, I want to tell you how extremely important it is that you fill out this evaluation form because it's very, very important to the committee. And trust me, your opinions are very important. Your opinions have a big impact on what subjects we cover, on what type of seminars we hold, on the speakers that we use in every one, on the value of the papers that we produce, and things of that nature. So if you'll be so kind as to fill out these today and tomorrow, that would be most helpful to us. And in terms of the evaluations, be kind. I know all these speakers and they have eggshell egos. So, all right. I tried a case in Beaumont, Texas, involving the death of a 9-month-old infant who had been given an overdose of digitalis. And the child died of digitoxin toxicity. The problem with it was that children in damages, infants, do not experience mental anguish. There's no guideline that they start experiencing. They wake up on their 3rd birthday and say, this is really a rotten day. There's no guideline. They just say you can't recover from mental anguish as a child. So I was trying this case in 1971, and the court wouldn't give me, he said, I'll give you mental anguish submission if you want to, but you're going to get overturned on appeal. So I said, no, I'm good the way it is. So we tried the case. After the trial, the judge said, and this is the important part, this leads to the whole thing we're talking about. The judge said to me, Mr. Nations, you did a great job on your closing argument. And in doing so, you created a big problem for yourself and for me, because the jury is going to return a verdict of more damages than I'll be able to uphold. And I'm going to have to enter a remediator. And it's a problem for you because you're going to have to explain to a jury why they don't recover the amount of damages that the jury awarded. And he was right. The jury came in, and then I talked him out of the remediator, but they took it up to the Beaumont Court of Appeals, and they remitted it. And it brought home to me the significance, the extreme significance of something that I was aware that law schools don't do. Law schools do not teach us how to prove damages. They may tell us what recoverable damages are, but they don't tell us how to go about creating a body of proof or the significance of a body of evidence for damages. So I've taught damages in law school for 25 years, and so I want to talk to you about what I've learned from that. And I sort of developed my own paradigm for evaluation and proof of damages that I've been using for all those years. What we don't do, what we fail to do as lawyers, is understand the importance of availability, the availability concept. I've always called it the spotlight theory as far as lawyers are concerned. The jurors will focus in deliberation where the evidence was focused in trial. What we don't do is we save the damages for closing argument. I'm going to give up there and do exactly what I did in that case in 1971. I'm going to give a slam-bang closing argument. They're going to bring in damages, and it's going to get set aside because I did not make the proof. So I learned the hard way in that case that I had to have proof to back up everything I said. So let's talk about how do you go about using, what is availability? The availability has an unconscious mind appeal. It goes directly to the unconscious mind of your jurors. The more evidence that you produce, and I understand this, I'm not talking about repetition of the same evidence. I'm talking about redundancy of your theme on evidence. It's coming at damages evidence from every different direction. Lay testimony, expert testimony, documentary evidence, demonstrative evidence, a body of evidence. And if you create a body of evidence, this can lead to focus in the conscious mind as well. So you're hitting all parts of the brain that are going to be deciding how much money your client gets. The unconscious mind appeal, the availability, is extremely important to the majority of today's jurors because now what we're getting are mostly the millennials. There are 86 million millennials. There are 40 million Gen Xers, and there are 80 million boomers, but most of the boomers have figured out how to get out of jury duty by now. So we're trying cases to our Gen Xers. They are very, very, very much unconscious mind people. So let's take a look at this. How many squares do you see in this box, in the screen? Okay. There's 16. But are there really? Okay. Now, it says 16 because that's all the evidence I'm presenting to you. If you look at it further, if I bring more evidence, there are actually 18. If I bring you more evidence through if I make available to you more evidence, there are really 22. I can make available further evidence that show that there are 26, 28, 30, 31, 32. So what I've actually done, now you see the availability, I made available to you 16, and then I kept adding what was available to you, and you saw that it actually doubled. That's what we have to do with damages. We have to make available evidence of damage. Arguments are fun. Evidence is hard, but you got to have both. So let's talk about how do we decide how to do that. How can you go about that? My position is that we should create a body of evidence that supports each individual element of damages. So let's talk about that. Take your elements, and start. I'm going to go through the elements real fast because we know what they are, but I want to point out to you that the point that you need a separate body of evidence. You take physical pain and suffering. Now, we'll put that up we'll get in our war room, we'll put up on the chalkboard, we'll put physical pain and suffering. And under that, we'll put every bit of evidence that we have, just on that one element. We put lay testimony. What witnesses do we have on physical pain and suffering, and what will they say? What is the amount, the quantity, and the quality of their evidence? Then we'll take documentary evidence. What documents do we have? Medical records that will substantiate an award for physical pain and suffering. What demonstrative evidence do we have that will support physical pain and suffering? And then we talk about creating additional demonstrative evidence, and we're going to talk about that substantially here shortly. But then we talk about, now, what expert witnesses do we have So lay testimony, expert testimony, documentary evidence, and demonstrative evidence, and we put it all up on the board. Then we move on to the next element. The defense has a tendency to talk about pain and anguish as if it were one element of damage. There's all the difference in the world in physical pain and suffering and mental anguish. And you should make a concerted effort to separate those two. You should produce your evidence separately, and you should argue your damages separately. One argument for physical pain, a separate argument for each one of the elements of damage that you can support in a closing argument. So I'll give you an example of this. I handled a case many years ago, tragic case. Young couple on their honeymoon. They were driving along the border on the American side, just across from Mexico. There's a lot of open fields out there where they were harvesting crops. And they're driving along this 2-lane highway, and all of a sudden this harvester, they swing the equipment around just in time that it protrudes out into their lane, no time to react, and it took the roof right off the car. And the car went into a spin, and by the time it stopped, the young driver, who had been a medic in Vietnam, he was sitting there frozen like this. He couldn't move. He had no movement in anything. He's holding on to the steering wheel. He's got all kind of pain, but he's holding on to the steering wheel, and he can't move. Finally, he manages to get some movement in his right arm. Now, he's got all kinds of pain. He has 2 broken scapulae. He has a broken leg, and he is frozen in place. He thinks he obviously has a neck injury, but he thinks he's quadriplegic. That's mental anguish. That's mental anguish. He's got a broken leg. That's physical pain. But then he reaches up and he knows not to try to move his head because he thinks he's got a broken neck. But instead he reaches up and grabs his shirt with the only thing he can move, which is his hand. And he pulls himself around like this, his whole body around till he can see his wife, who's been decapitated. That's mental anguish. See the difference? So you need a body of proof on each one of those. Now, physical disfigurement, physical impairment, which is disability, bystander mental anguish, these are the elements that you can look into. Loss of society and companionship, loss of consortium. We have these as a checklist, and we use this checklist on every case, every personal injury case we get. We run it down the checklist, and you'll be surprised how often you find, whoops, I had forgotten about that. So, and the checklist is available in your paper. Loss of damage to wage earning capacity. I hear a lot that, well, he doesn't have any damage to wage earning capacity because he's making more money now than he was before he was injured. That's not the test. There's wage loss, but then there's wage earning capacity. So if he had a capacity to earn money before he was injured that he does not have now, something was injured that's reduced a capacity that he had to make money before, he has damage to wage earning capacity. Then there's wage loss. Then you go into medical expenses, pharmaceuticals. A lot of time you overlook pharmaceuticals because you say, well, it's only $12 a week or whatever. Run that out over somebody that's going to have to take it for their entire life. Do a lifetime projection on pharmaceuticals. You'll be amazed at the amount of money it comes out to. Funeral expenses, and then you go into the other things. Personal property damage, cost of vehicle repairs, rental car, pre-impact terror is an element of damage, which we'll talk about. Loss of chance of survival in some states. Attorney's fees. I'm amazed at the number of times that lawyers fail to plead attorney's fees where they might be available. Now, this is not in personal injury necessarily, but I've done a lot of cases that involve federal legislation. There are so many federal statutes that provide for attorney's fees if you breach them. But we had a statute in Texas, Article 3.62 of the Insurance Code, that said if someone dies and they're insured and you don't pay off the insurance coverage, you get a 60-day notice on it. You give them 60 days. If they don't pay you in 60 days, you're entitled to your attorney's fees, an 18% penalty, plus attorney's fees, plus prejudgment interest and post-judgment interest. I defended over 100 of those cases. And in maybe 10 cases, the lawyers, this was working for the forces of evil, then in maybe 10 of those cases, about 10%, the lawyers actually pled for all that money that can drive a $100,000 policy up to $225,000 or $230,000. All they had to do was plead it. But so look for these things. You have your consumer protections, contractual damages, bad faith, pre- and post-judgment interest, and punitive damages. Now, a lot of that won't do you any good at all unless you can find the coverage. Always exhaust coverage, and here's a big tip for you. Carriers will lie about their coverage. Aren't you shocked? No, they will. No, I know you don't believe it, but they will. They will lie about their coverage. They will also defraud. They'll go further than lie. They will defraud about their coverage. So you depose, if you have any question about it, if you get damages far in excess of what they claim they have, you tell them you want to depose the underwriter. And it's an amazing thing. The other thing is, read the policy. Read the policy yourself. Don't take their word for anything. But it's the excess coverage is what they hide. You got the policy, but they'll hide excess coverage. So you pursue all coverage and don't take anyone's. I could do a whole speech right now on all the times that I've caught insurance companies lying about coverage, and we've discovered it. Take no one's word on coverage. Now, here's my approach to proof of damages. I call it the segmental approach. What we do to create a body of proof is we take this. We take each element of damage, and we take each step along the way, each segment, and pre-impact terror may not apply. I've had some cases where it applied. There was a case in the classic on pre-impact terror is where the plane there was an explosion of the Air Florida plane, and it took it 7 minutes to land when everybody knows they're doomed. So the jury awarded $500,000 for pre-impact terror for that element alone of 7 minutes of mental anguish knowing that they're about to die. So you look at, in any case, you look at the actual instance of impact, and you sit down with your client in the interview and you say, okay, I want to take you back now. I want you to think back to exactly what physiologically happened to your body at the moment of impact. And tell me, let's walk through it and take them through it. And they'll tell you what was broken, what hurt, what was your first notice that you had injury to this and this and this. And you go through the entire, their mental anguish, their physical pain at impact. Now, we go through this process with each element of damage. So we take physical pain. Now, talk to me about your physical pain now. Then we come back and we go through all those same steps with mental anguish and do it separately. And you'll begin to develop a hell of a body of proof. Post-impact unassisted. A lot of situations you'll have where they have an impact and then they can't, they're out, no one's stopping to help them. The other party may be injured or dead. And we've had these cases where there's no assistance and they're there and there's nothing can happen. I had a case of a woman whose leg had to be amputated eventually, but her leg was crushed and she can't move. She can't open the door. She can't do anything. She's just sitting there in horrible pain for the longest period of time, 23 minutes to be exact. 23 minutes she can do absolutely nothing. And there's a lot of pain involved in that, and nobody could help her. There was nobody there to help her. The period of peril. There's always a period of peril, quite often a period of peril, after the first impact. There's the peril of somebody else hitting your car. There is the fear of the peril of the car blowing. If you're not extricated from the vehicle, there's the fear that the gas tank's going to blow up, that there's going to be a fire, that you're going to burn to death. I have to tell you about a guy I represented that illustrates 2 or 3 of these points. I had this big Texas construction worker, and he rode a motorcycle, and he was riding his motorcycle home from the construction site one night, and there was a brand new coverage of asphalt on the highway that they just put down that day. And when the workers left at 5 o'clock, they sort of forgot to put up the barricades. He happened to be the first guy to come along. He goes off into brand new asphalt. His bike flips. He is thrown, propelled rather fast, on his back and his butt across that, literally just being thrown across that fresh asphalt. And at the meantime, the bike is flipping over. When he finally stops, the bike lands on top of him, breaks his leg. The gas tank is busted, and now he's laying there with gas spilling out on him, and his leg is broken, and he can't move. Oh, and he also had shock to his spine, and he can't move. Okay, he can move enough to look and see that there's a car bearing down on him. This is a period of peril. He's sitting there. He could burn to death in any second now. He could be run over by the oncoming vehicle. All sorts of things. Okay, so is there mental anguish involved in that? I think so. Is there physical pain involved? Yeah. The woman the car who came right behind him, when the next people came up and they stopped, they came up and they testified that she was sitting in her car gripping the steering wheel, and she was screaming at the top of her lungs. She thought she had hit him. She was that close. He was actually under her front bumper. She didn't contact him, but she thought she'd killed him because he wasn't moving. She couldn't see anything out there. She thought she'd killed him. Period of peril. People often get hit on highways. It actually happens on highways. And there's oncoming traffic. The traffic's still flying by on the interstate, but yet they're right there in a danger zone. Mental anguish. During rescue, remember this, that during rescue, whether it's by EMTs or by Good Samaritans, people will often have the best of intentions, but they can cause a lot of pain and mental anguish in the process too. The fellow who was in the car, he had 2 broken scapulae, and he had a fractured leg, and he had bad back injury. So people came up, and they came over. They were worried about the car catching fire, so they took him, and they reached up in under his arms where he had 2 fractured scapulae. They didn't know. So they pulled him out in a hurry because they're really worried about the car catching fire, and they dragged him away from the car. So he's bouncing along the ground with these guys holding on to and he also had fractured rib fractures and scapulae. Pain involved in that? Yeah, I think so. And so look at what happens during rescue, because a lot of times during rescue and at the scene, you'll find that the EMTs will come, but they don't worry. There are all sorts of cut downs that occur. There are all sorts of things that happen with scalpels at the scene. There are a lot of things involved in the rescue process itself. One of my clients was hit by an 18-wheeler, and the fenders were crushed in, and the metal was impaled into his legs, and they couldn't take it. They couldn't take him out at all, and he had to wait there until they got there with the jaws of death, and they take the jaws of death, but they can't pull the fender out, but they can't take it out because it's really deeply into his leg. And I mean, just think about the physical pain involved in that. They're trying to pull this metal out, and I mean that's pain and suffering. Also a little mental anguish, and there's always the mental anguish that goes on with that type of injury also. During transportation, the same thing is true. You get the EMTs, some of your best witnesses, some of the best witnesses I've ever had on physical pain and suffering, and have been the EMTs, the people who are at the scene and then taking them to the hospital, talking about all the problems that they had and all the dangers that they were in during transportation. In the case of our young man who had he thought he was quadriplegic with good reason. He did have a spinal shock, and they put him on the stretcher. They anchor his neck down, and he knows what's happening. They're fixing him so he can't move. And then they take him by ambulance to the local hospital in Hidalgo. The local hospital says, this is too serious for us, we can't handle it. So he had to wait while the Medijet comes to get him and take him to Houston. They take him to Houston. They have to transport him by helicopter from the airport. And so this whole time, he's being treated by the professionals as a quadriplegic, and he thinks he's quadriplegic. He wasn't quadriplegic, but imagine the mental anguish this guy's got. His wife is dead. He's just seen this horrible picture of her in his mind, decapitated, and now he thinks he's quadriplegic. He's got enough real injuries without the quadriplegia, but that's huge, huge. And this is hours by the time they finally get him into to the first relief. The emergency room care is often the same thing. Look at what happens in the emergency rooms in terms of pain and suffering and mental anguish. The time to first relief. This is an interesting calculation, and I've seen it run as long as 18 hours. The question is not how long was it between your injury and the time you got to the hospital. The question is, on the issue of pain and suffering and mental anguish too, the question is, how long was it from the time that you were injured until you first got relief, which is to say something to reduce your pain or something to try to control your mental anguish. Because what happens is when they get to the hospital, the doctors are concerned with differential diagnosis. So they do not want they don't want to relieve your pain because physical pain is a very important differential diagnostic tool that doctors use to say, does it hurt here? Does it hurt here? They don't want to, if they stop the pain, you can't tell them where it hurts. So you'll find, I found in one case, I said, that it was actually 18 hours from the time of the really, really bad injuries until they finally got this person to where they could get them into bed and put a morphine drip in to start trying to relieve their pain. That is a lot of time of very severe pain and mental anguish. Major versus minor injuries. I'll show you this in a minute in a graphic, but we often make this mistake. You get a person with a major injury like quadriplegia, and they will have all sorts of other injuries, but you just focus on the quadriplegia because it's such a big injury, and you don't think about all those other little fractures they had. You don't think about the pneumothorax or the other fractures. So here's what I learned this a long time ago, and we've always done this. We get a quadriplegia case or a paraplegia case or something of that nature. I'll take an associate and say, okay, here's what I want you to do. You take this file and you leave out the paraplegia, but you evaluate this case for trial and for damages and for settlement prospects based on everything else that's wrong with this patient, so that you work up every single solitary thing there is, every minor injury there is, you get a cumulative total on those and evaluate it that way. Then you add the paraplegia in, because it's very easy. You can overlook lots and lots of money for minor injuries because you're so focused on nothing but the major injury. The next is treatment and therapy. There is so much, a lot of times, and you have to go into detail. This is where your nurses come in and your rehabilitation specialists. But the fellow who was thrown off the bike, there is no way he would ever say under any circumstances that he was experiencing physical pain. Just wouldn't happen. He was just too damn tough for physical pain. But what happened to him was, I have an RN JD who has been working with me for about 37 years now, same in your class actually. And she was going through the medical records on this guy. I told her, I said, read she'd go through and read every page of the medical records, every entry, and say, find instances in here of physical pain, mental anguish, reflections of these damages. And so she comes back in, she says, well, this is significant. And what it said was, there were 4 pages there were entries on 4 different pages, a nurse's entry. And all it said was BET times 2, BET times 2, BET times 3, BET times 3 over a 4-day period. She said, this is great stuff here. And I said, okay, well, let's go talk to the nurse. So we went and talked to the nurse, and she explained to me that means a betadine scrub, but there's a reason for it. So we talked to the nurse, and the nurse's testimony was this. She said, that is a betadine scrub. She said, what I have to do is I have to go in. He had all this fresh asphalt embedded in his back. I mean, deeply embedded in his back and in his butt. And she said, I had to go through and I had to take tweezers and dig down in and just dig that asphalt out and just dig it out. And then I'd take the betadine, which is an antiseptic, and I'd take that and I'd scrub him down with it. Then I'd have to go through and dig all that out. And I said, well, why did you have to do it 10 times? You had 2 2s and 2 3s. And she said, oh, you couldn't possibly tolerate that much pain to do it all at one time. He had it all the way from up here, all the way down his butt. And she said, no, he couldn't possibly, I wouldn't put a patient through that. And I said, well, explain it to me. She said, well, he's stretched out, he's on his stomach, and I'm in there, and I'm telling him. And I said, I wrapped up a towel, folded up a towel, and I said, okay, bite down on this. He said, what's that for? And he said, I don't want you to cry. I don't want you crying out and screaming. And he said, I'm not going to scream. She said, no, this is not for you. This is so you don't disturb the patients down the hall. So he bit down on the towel, and I said, okay. And did he scream? She said he screamed into the towel, but he cried like a baby. Okay? Why did you have to do it? And so we went over how long, and she did this 4 days in a row. So the treatment itself, I mean, that's huge damages in that particular case, in a lot of cases. And then there's a time between treatments. There are a lot of bad treatment courses that patients have to have in hospitals. So just like this guy, he gets his first day of treatments, then he's got to lay there and think about, boy, I got to do this. Here comes the nurse again at 3 o'clock. But there's also this. I had a case in which a truck driver was told that he had a risk of he had a risk of dying, and that it was gangrene, but they had to stop it. He said, we think we should take your leg off. It's possible you won't lose your leg, but on the other hand, if you don't have your leg amputated, you could lose your life. So they came in, explained it to him at 3 o'clock in the afternoon. They said, okay, he said, man, that's a tough decision. So he said, we'll be back in here at 7 o'clock in the morning, and you let us know, we'll proceed or not. So here from 3 o'clock in the afternoon till 7 a.m. the next morning, he's got to decide, do I want to have my leg amputated, or do I want to just take a risk, in which case I might die? That's tough. I would imagine there's some mental anguish involved in that. The next is informed consent. Did you ever read the informed consent form? You should. The informed consent form says, you'll be put under general anesthesia, which can cause brain damage, and then it goes into all these other things that can happen. You may have to be given blood transfusions, which could possibly cause AIDS. I mean, literally, it could possibly cause AIDS, and it goes through all these. Then it says, of course, you may not have to worry about it at all because you may die. Here, sign here, we'll see you at 7 in the morning. Have a nice night. The informed consent thing scares the hell out of patients. You talk about causing mental anguish, it does. Preoperative testing, find out exactly what preoperative testing they underwent, because the testing, quite often, you take someone who's got fractures all over the place, and they have to put them in just for x-rays. But to get x-rays, we got to put you in this position. There's a lot of pain. It might very well, if you got somebody with rib fractures, something like that. When they're x-raying, they don't know what they have yet in most cases. So just look into that. The next thing is in surgery. Do not assume that because they were in surgery that they were under a general anesthetic. Spinal blocks, there are all sorts of surgeries that are done now without general anesthesia. There are also surgeries that require, even brain surgeries, that require that the patient be awake and communicating. And so, here you are, you're awake, and you got this guy playing around in your brain up here and asking you questions. Or there's some cases where they use a spinal block, and they say, okay, what's that I smell, doc? Well, that's your skin burning. It can be terrible mental anguish in cases that do not involve general anesthesia. The postoperative recovery is always a frustrating period in many types in physical trauma. It's usually a very frustrating period. Then we get into what we call prosthetic frustration, which is when you get someone who's all of a sudden they're having to learn to walk all over again. And there's so much frustration. And first they just have to learn to stand upright. Then they have to learn to take a step with rails. The whole frustration of using a prosthesis and having to be trained to work, there's a much mental anguish. So this all comes from rehab people. And they call it the anguish of assimilation. The whole process you have to go through to assimilate from being a healthy, full-bodied person into being someone with prosthesis who has to learn to live without an arm or a leg, or in one of my clients, 2 legs, a double amputee. So those are segments that you look into. Then you go to the rehabilitation process, and in all of these, the rehabilitation process is hard, it's frustrating, it's a major source of mental anguish. Then you talk to the spouse, to the family, about when they return home, they can no longer perform what they used to do before. This is physical disability. The inability to perform the task that you could perform before that does not require wage earning. Are recreation disabilities. Those things that you used to do for recreation that you can know. That's all part of the damage element of physical disability. These are often overlooked. You can build up quite a substantial list of things just on the physical disability element. Return to the workplace. Then you go back and talk about damage to wage earning capacity. You talk to the employer, talk to the co-workers. What were the things that this person used to do that they can no longer do now because of this injury? And you get help on that from the workers, co-workers. Future damages. You got your life care plan. You calculate the current life expectancy. And I always plead future damages. And in my years of teaching damages, I always told my students, I said, always plead future damages, because if you plead them and you don't prove them, no harm, no foul. But if you don't plead them and you try to prove them, you may run into problems on a trial amendment or something like that. So always plead future damages. So we hired a guy who had been one of my students, and one of my associates came in a few months later, and he said, "Boy, he took you to heart on that pleading future damages thing." He said, "You need to read this." And I read this paragraph, and it said, "Decedent has incurred funeral expenses in the past, and in all reasonable probability will incur funeral expenses for an indefinite period of time in the future." And so I called him in. I said, "What are we dealing with here, the eternal flame?" And he said, "No, the suit was rented." So on your future damages, your life care plan, and everything, that can be so much money, and it's so often overlooked. Now, look for your collateral sources, your PIP. A lot of these are often overlooked. Just look for every possible source of money when you're getting into damages. Look at every way you can get medical help, any types of benefits. Now, talk among yourselves for a moment, because I have to switch over and get to another part of the presentation. Let's see here, where did I put that? Yeah. Sorry, but there was no quick and easy way to do this. Okay. I go up to here. All right. Visual proof of damages. This is absolutely required with Generation Y, with the millennials. They're not going to listen to they won't even talk to each other. What makes you think they're going to listen to you? So you've got to involve them. Now, the way to involve them is with this presentation of the future damages. So, I mean, of the visual damages. Now, let's look at this for a moment. Let's take this young lady. This is an 8-year-old girl. Oh, first of all, I forgot, sorry. This is a case in which a car was hit by an 18-wheeler. Mother's driving, and she's comatose. and brain injured. The father is on the right front seat. He has a mild brain injury, which is the most difficult type to prove. The 8-year-old girl is behind the father. She has a mild brain injury. She is examined by a defense neuropsychologist who said that she has a tendency to stumble, which may have predated the accident, which is all he could find wrong with her. And then the 8-month-old child is dead, is killed, properly strapped in the seat and all that, everything proper, is killed. So this is the young lady. The neuropsych couldn't find anything wrong. The defense neuropsych couldn't find anything wrong with it. Now, when you want to try to prove something as obscure in terms of physical evidence as a mild brain injury, this is a classic example of proving all of your every aspect there is. You want to prove the impact. You want to prove every injury they have because it all supports your theory. So you start, when you're proving something like this, your starting point is this. This is the vehicle they were in, the remains of it at least. And when you see a vehicle like this, you can see the chaos that must have ensued inside that vehicle when it's hit. So this is your first impression. This is your first impression on damages. You start with this because, as Lisa so wisely said, you only get one chance to make a first impression. The importance psychologically of the first impression, if the first impression is powerful enough, and then you build onto the first impression immediately, it will create a mindset in your juror that will be harder to overcome. So the same thing is if you start with a bad first impression, it's going to be harder. So you want to start with a strong first impression, and then you build on it. Now, this is the first impression. Then we go back to here, and we go to this young lady. Now, she has a traumatic brain injury, closed head traumatic brain injury. So we're going to prove that she has the brain trauma that she has is the one where you're hit on the left side of the head, but the injury occurs on the right side of the head. And try to explain that to a jury, why she's hurt over here when she took a blow over here. So you need to have something that engages them. You can hear that, but it doesn't mean much to you. So you have to engage them. So we explain it to them. So we start, before we do anything, we start by showing where she was hit. So we start with a left skull fracture. So we show the fracture. Then we go to a laceration. And the laceration in and of itself is no big deal, but it's just one more thing added to impact to support the proposition that she has this injury, because the type of injury we're going to prove doesn't show up on X-ray, it doesn't show up on MRI, it doesn't show up on CAT scan, it shows up on neuropsychological testing. So, and the first question they always ask is, now you're not a medical doctor, are you? And incidentally, your doctor's answer to that question should be, no, I'm the person that MDs refer these type of cases to. So, but it's not an MD. Still, it's a problem. So we've got these different blows to her head, but now let's look at what happened. So this is the graphic that we created on this, and we've done this for years, and we keep improving it every time we can. We show them to focus groups. So you get the impact here. The brain collides with the skull. Then it bounces over because of the fluidity in the brain and the space in there. It hits the other side, and that's where the injury occurs. Now, it's called a diffuse axonal injury. So the axons are the highways of communication in the brain. And so what happens, you'll see the blow here where the impact occurs. So they're carrying signals. The blow occurs right there, the stretching, and now you have the axonal shearing occurs, and now that highway is closed. And you've got this happening with millions of axons, so every axon that is broken, you now have a closed pathway of communication. And then we'll show the effect of that pathway of communication. Now, she got findings of PTSD, post-traumatic cognitive deficits, and post-traumatic affective disorder, and attention deficit disorder. But this is something I worked on for a long time because I tried a lot of traumatic brain injury cases and trying to convince people the more tort reform set in, the harder it became to prove these mild brain injury cases because you can't see it on X-ray, MRI, or anything, and it has to be done. So it became more and more important for us to be able to illustrate this through evidence that they could understand. So we developed this chart. We tried to make it interactive or try to make it in such a way that the doctor comes in, first of all, a neuropsychologist takes a stand. He goes through all these different tests. Here's your intellectual functioning, verbal learning, and he tells what the test is. He tells how it's performed. He tells what the purpose of it is. He tells what the findings mean, what disabilities are associated with the findings. So he goes through all of these, and you see all these tests up here. Usually the most important of which is the executive function. So with each one, you break it out in this fashion, and it shows you now. You get over to executive function, which is the big issue here. Now, you see how this works. The severe deficit's down here, moderate deficit, mild deficit. So the coral color is at least a mild deficit, but at this level, it's moderate deficit, and down here it's a severe deficit. So you take this sequencing speed, it's the lower 1%, 1 percentile. That's as low. I thought that was as low as you could get. I never saw anything at 1/2 percentile until I saw this. But you look at all these functions, all these processing functions here across the board, and it's pretty clear that this child has, when he says that she has loss of executive function, which is extremely, extremely important to our daily living, here, this is executive function over here. And everything she has is at or right below 10th percentile out of 100. So this child is severely injured. And then we can walk through, we take 3 hours to put a neuropsychologist on the stand with this because you walk through every one of these. Now that the jury's getting something they can hang their hat on. So now we go back to films. And on films, the CAT scan doesn't show any brain injury of any nature other than you can go to the skull and it'll show the skull fracture, but it doesn't show anything in terms of of an injury other than this, the skull fracture. MRI gets into it with a little more detail, but it's also not going to show a lot of injuries. So again, you're just verifying what they say. You show what it'll show. But now you get into EEG, same thing. Now you come to we come to this MRI, and we take the sagittal view on this, and when we get into this, you see what we have here? We have the graphic over here, but this is the actual MRI here. And what we locate in here is this little dot right here. And this little dot right here is actually a void. It's a hole. It's a hole in the brain. It's a hole in the corpus callosum, which is located halfway. It's the dividing point between the right and left hemisphere of the brain. So this sagittal view shows an actual physical injury to the child in the brain. So then we wanted more than that because it still doesn't show everything we wanted to show. So we brought her down to Houston, to Texas Children's Hospital, where they're doing the most advanced testing in the world. And the latest thing at the time we did this was diffuse tensor imaging. And this shows up, this just flies off the screen at you when you see the actual screen, but unfortunately it doesn't translate to PowerPoint very well. But what happens is they color code the fibers in the brain. So this is a normal 8-year-old girl, and this is our client. And you see these big voids in here? That's because these brain fibers in here are dead. There's no activity in those brain fibers. And so then you can spin it around and show, I keep having trouble with that thing. You can spin it around and show or you can sync it and you can stop it at any point along in here and compare it to the other child. Now, this is the other one I was telling you about, where you show you show not just the major injury. She was comatose. But you show not just the major injury, but you show every little bitty injury that there is. You accumulate everything, major and minor injuries. So we go through here, and we've got the head injury, which is the same as the other. She has a diffuse axonal injury, which has the same illustration. Then we go into scalp laceration. Then we show, so again, we're showing blunt trauma to the face. And then these are all the bones. See all those little gray lines there? Each of those is a bone that's broken. Those are broken bones in her face. Just crushed her face, obviously. And then we can click here and go into all the CT data on that, but I don't have time to do that. All right, so she has a left arm laceration, which would be easy to overlook. She has a femoral fracture. She has a tibial fracture. She has multiple rib fractures. Another thing to be easy to overlook, she has a pneumothorax, which is a collapsed lung right here. And then she also has sepsis throughout her body. So then we go into the post-traumatic injuries. She has cervicogenic headaches. And then look at this. This alone would be bad enough. She has TMJ. I've had TMJ cases that were just absolutely terrible. So you see the extent of her TMJ injury here, and what they have to do to correct it. Then we go through all the other things with myalgia, articular disc disorder, straightening of the lordotic curve. So she has loss of the lordotic curve and spine spasms and pain. And then she's post-traumatic cognitive deficits, stress disorder, affective disorder, and confusional state. And she was also in a coma. And she is, you talk about mental anguish. The father called me to come up, and he said, look, I don't know how I'm going to do this. Our 8-month-old baby is deceased. They had 6 children, 3 of his, 2 of hers from prior marriages. Then they had 1 of theirs, and the 1 of theirs is the one that was killed. And he said, I've got to bury our child, and she's still in a coma. I can't face her and tell her, A, our child is dead, and B, you never get closure because we've already buried him. So he stayed with that, and there was no sign that it was going to get any better. Talk about that kind of decision. And I mean, I saw that. I saw this mental anguish. I saw a big grown man cry with this decision. What do I do about this? And finally, he had me, you may have heard this story, but he had me come up. And I went in, and he said, she's just come out. And they went ahead and buried the child because the doctor said there's no telling how long she'll be in a coma. So this is the one where I went up. He called me and said, she just came out of a coma and she wants to talk to you. I said, fine, I'll be right there. So I went there, went to the hospital, and I walked in the hospital room with the husband, and this doctor was in there, and he looks at me and he says, who the hell is this? And the client said, this is our lawyer. And he said, well, you got to get the hell out of here. He said, I'm not going to work here with some damn lawyer looking over my shoulder. He said, I'm trying to repair your lives here. And he said, my client very wisely said, no, doctor, our lawyer is repairing our lives. You're repairing our bodies. In which case, the doctor cut her artery and let her die. So, but, there's a lot of truth in that. When you think about it, there's so much truth in that. And I thought that was a good definition of what we do. I want to show you, these are all, what I'm going over here, these are all surgeries. All surgeries, and we have graphics on all of them. But let me just show you here. Let's look at this. This is a femoral fracture. Now, go over here to the surgery, open reduction, internal fixation of the femur. It doesn't sound like much. They put a pin in her leg. Well, a pin, when you think of pin, this is a pin, or some little thing is a pin, and pin's like this long. But you see what happens here? When you actually show them what happens, the idea of taking a drill and drilling it up, drilling out the leg, the bone, the femoral bone, and then putting this, here's the actual pin, the intramedullary nail. And then on top of that, put screws in it to hold it in place. Well, all that can get pretty painful along the way when you're trying to live now with the pin in your leg. So as far as the child was concerned, we had a long presentation, but I'm just going to show you one picture I think kind of tells the whole story. Look at the size of that casket. That kind of tells you, that speaks volumes, I think. Let me go back to this, get out of here, and go back to here, and back to here. Now, let's talk. We talked about your body of evidence: lay witnesses, expert witnesses, documentary evidence, and demonstrative evidence. Now, your lay witnesses, you want to find everyone, because this is the evidence. You want to find everyone who was present at the scene, especially neutrals who were present at the scene, because neutrals, people that stopped to help, the Good Samaritans, people who are in the neighborhood who just happened to be around there. You want to find everybody who was at the scene, everybody whose name appears on the police report or on the EMT record, anybody that they got a statement from at the scene, and you want to talk to everybody, and you want them to testify to what they witnessed at the scene of the physical pain and the mental anguish of your clients. A very good source, it's hard to lose on this one, the defendant was always at the scene. The other driver, always asked the defendant driver to describe the physical pain, to describe what did the plaintiff, did you see the plaintiff? Yes, what did the plaintiff look like? Tell us what Mr. Jones looked like. What was he experiencing? And if they try to downplay it, they look bad. If they tell the truth about it, if they describe all that pain, then you've got the best witness you can have on that, which is the other side. But the one I had where the fella had the fender of the car impaled into his leg, it was an 18-wheeler. And this is what you'll get from 18-wheeler drivers. I asked the driver, I said, now, did you call when were you knocked unconscious? No, I wasn't. Tell us, did you call 911 to report this when it happened? He said, no. I said, well, did you get out of the car immediately to go help him? He said, no. I said, did you make another phone call? Is that why you didn't get out of the car or your truck? And he said, yeah. I said, well, who did you call? The same people they're always instructed to call. I called our investigator. I called our investigative team so that they could dispatch our investigative team to the scene immediately. So your immediate response was not to call 911 to help the man. And he's looking down. He could see from his windshield. He could see through his windshield. He could see the plaintiff. I said, so you made no effort to call to get. You could see. Was he in pain? And tell us what he was suffering? He said, well, he looked okay. Okay. Did you ever get down and go down? No. Did you witness them take him? Yeah. And so then I had him describe how they let him describe the whole process of how they had to go through and how they extricated him and so forth. Okay. You lay witnesses. You want family and friends who. And the person we use the least, incidentally, the person we use the least is the plaintiff. You don't want the plaintiff to be talking about their pain and suffering unless there's no other way to prove it. But you heard Eric talk about how the dumbest thing is they fail to do this and they fail to do that. You're right, obviously. But you don't say the doctor failed to do this. You say the doctor chose to do this. And you present it as a positive. And you present it as a positive because that way it resonates with the unconscious mind. The unconscious mind sorts out positive and negative and just sorts the negatives to the side, does not register negative. So if you want to communicate with the unconscious mind, you communicate in the positive. So what you're doing here is you want the family and friends to be the one that will be complaining about what he can no longer do that he could do before, the physical pain, the mental anguish. All these people are testifying. What the plaintiff testifies about is not what's wrong with him. It's not that I'm hurting here and I'm hurting here and I can't do this. What you want him to testify to is his courage. He wants to be presenting a position of courage. Here's what I'm doing now. Well, why are you doing that? Well, because I can't walk on this leg, or I can't get used to this. But it's not again, it's just pure courage on his part. In my opinion, that's the best way you can project a plaintiff, is courage. Everybody else is projected. Everybody else proves up the pain and suffering, mental anguish, because you've got to overcome the jury bias where they don't believe the plaintiffs, and you need to create so you don't want a whining plaintiff. That's the worst thing you can have on the stand, is a whining plaintiff. But it's hard for the defense to deal with a plaintiff who is just simply telling the story of his courage, the courage that was involved. Now, you want to look for your healthcare providers as witnesses, your rehab team, your life care planners. Then on your documentary and demonstrative evidence, here's how we approach it. Number one, what's available? Everything that's available in terms of documentary evidence for each element of damage, anything we can find. Second, how can it be simplified so that make sure, as Albert Einstein said, make everything as simple as possible and no simpler. But if it got a complicated situation, you don't have to live with it. How can it be simplified to bring it down to a jury level? You just ask yourself, could George Bush understand this? It's a simple test. How can it be enhanced? All right, that's an important question. And it's a simple example. You take an X-ray and you turn it into a positive and mount it on a board and blow it up, put it up, and now they can look at it. They don't have to look through an X-ray machine. The next thing is, when you put all this evidence, you got your board filled up now. You're all around the room and you've got everything, every element of damage up there. You've got who can testify to it. You got what documents do you have to support it. You got what demonstrative evidence do you have to support it. So now you've got everything covered. And now you can stand there and look around, look at the board, and you can see, where are the holes in my evidence? I'm short over here. What can I do to fill in this hole in my evidence on this element of damage? So then, what can be created? And what can be created is what I just showed you. Everything you just saw in that whole presentation was created except the picture of the vehicle. So, and that's particularly important. Now, reference points. In the Trilogy of Persuasion, I like to use a reference point on damages. And there's a big debate about whether you should mention damages and put a number on damages in your opening statement or not. I mean, not an opening statement, but on voir dire examination. But here's what I like to do. If you can get a supplemental juror questionnaire, then you put the question in supplemental juror questionnaire, and you can state it as you saw Lisa do, and I learned all this stuff from Lisa. You can you can use a scaled question, and your question can either be a statement of, if the evidence supports it, I can award damages of $1 million, $10 million, or whatever you want your reference point number to be, because this is where they hear the number for the first time, is on the questionnaire. If the evidence supports it, I can award $1 million. I can award $10 million for a personal injury or a wrongful death, whatever it is. Scale it from 1 to 10. Or you can scale it the other way. regardless of the evidence, I could never award $10 million for a personal injury. Now, that's the one you really want. Why? Because that'll disqualify a juror. If they answer that they could not, then they've just disqualified themselves, because it says regardless of the evidence, I could never do it. Then that's how you get your tort. That's one way you get the tort reformers off, unless they've been trained for it. Now, what I like to do on opening statement, and whether you do it on voir dire or not depends on lots of things, and I leave voir dire to my expert over here. I was asked one time on voir dire, Your Honor, we'd like to know what Mr. Nations is suing for. And I said, this case involves millions and millions of dollars. That's all I said on voir dire. And the defense lawyer stood up and said, Your Honor, we have a right to know what Mr. Nations is suing for. And the judge said, Mr. Nations? I said, millions and millions of dollars, Your Honor. She said, fine, you may proceed. So I never like to put a figure. Don't put a figure on it, because you never know what's going to happen to the evidence. Now, one of the things I like to do in opening, and I think this is very important, as opposed to everything else I've told you, in opening statement, I like to put up what I call road signs, or signposts. I explain to them, as we all do, that you have a power that the judge doesn't have. You are the sole judges of the amount of money that can be used to compensate, even begin to compensate, for the damages suffered by the plaintiff in this case. You're going to be called upon, and you're going to hear me put on evidence. And I'm going to call witnesses who are going to talk about the physical pain that Mr. Jones suffered, the mental anguish that Mr. Jones suffered. But I want to tell you now that is because I have the burden of proving that to you, and you have the important task of putting a dollar value on those elements of pain and suffering, mental anguish, physical disability, whatever. So when I'm putting that evidence on, it's to assist you in arriving at that number. Now, as you then go through the evidence, and you put a witness on, and you have the nurse up there and say, oh, they're talking about him being hospitalized. Now you say, now, Nurse Jones, let's turn to the element of physical pain and suffering. So you give them a signpost. You've told them, we're going to do this. It's the military method of teaching. You tell them what you're going to tell them, then you tell them, then you tell them what you told them. So you've told them what you're going to tell them. I'm going to prove this for you. Now, leading into the question, you say, now let's turn to evidence of your testimony about physical pain and suffering, or mental anguish, or whatever it is, so that they understand why and when and why you're doing that. As far as summation is concerned, damages and summation, you save the emotional appeal for the second half, for your second opportunity. I put on just enough evidence about damages in my opening part to qualify, but then I save my damages for closing, and especially the emotional part, so that they do not have the opportunity to reply to it. How much time I do? How much? Oh, okay. All right. I already talked about that. Let's see. All right. Let's talk about some real quick principles. And this is important too, especially now with our Gen X, with our millennials again. In communicating your message about damages or anything else, your verbal communication is only 8% of the delivery of your message. I'm not saying words are not important, they're extremely important, but they're only 8% of the delivery of your message. The vocal communication is 37% of the delivery of your message. And nonverbal communication is 55% of the delivery of your message. So it's very, very important. The vocal, the reason it's so important is because that's where they're reading your sincerity. If you are just standing up there going through the motions and you don't believe in your case, it's what Jerry was talking about this morning with the poor defense counsel who have to come in there and meet they come in and meet their client for 30 minutes before they have to go out and try to keep them out of jail. Well, they're going through the motions. It's unfortunate, but they are. So if you don't believe in your case, then get the hell out of the way and let somebody try your case that does believe in it, because there's where they'll nail you. They'll nail you on the vocal, because that's what carries your voice, and your eye contact is what carries sincerity. That's your belief in the case. And if you don't believe in it, why should they? So those are important. But what's equally important is what Milton Erickson taught us, the importance of the synthesis between verbal, nonverbal, and vocal communication. If you are saying one thing and your nonverbal communication with your client and with them about your client is saying something else, then the nonverbal will prevail every single time. Every single time. It's 7 times as important in delivery of the message. And what happens if you're given a verbal message and a different nonverbal message, then they realize that your verbal message was what? It's a lie. So if your verbal message is a lie, your trustworthiness just went down the tube. You lose your trustworthiness. You've lost your case unless the defense lawyer is even more untrustworthy than you are, which he always is, but they may not recognize it. All right, so let me tell you very quickly about the unconscious mind appeal and the conscious mind appeal. I've been talking about this, as Eric said, I've been talking about this for 30, 35 years. Daniel Kahneman just wrote this incredible, incredible book, which is all about what he calls System 1 and System 2. He calls it fast thinking. This is thinking fast and slow. The man got the Nobel Prize in economics for the work that's manifested in this book. He knows a little something about communication. We take it and apply it to trials. What he calls slow thinking is the conscious mind appeal. What he calls fast thinking, fast thinking just means you get it right away. You don't process it through your conscious mind. So he has brilliant data in there. The conscious mind appeal, and this is how you reach people through the conscious mind, is the hard evidence, the court's charge, your visual evidence, which is both conscious and unconscious, and your supported numbers, and the word is supported. You should have a reason. Come up with one, whatever it takes. Think about it in advance. Have a reason for your number. Nothing falls flatter than, well, with respect to physical pain and mental anguish, I think that should be $500,000. Why not $500 million? Have a reason. Have a reason for any, just like I think in the McDonald's case, the damages were based on 1 day of coffee sales by McDonald's in all their places around the world. But have a reason for your numbers. The unconscious mind is direct communication with the portion of the brain where fast decisions are made. This is the absolute definition of your millennials. They don't think, they work so fast, if you don't get their attention and hold it immediately, but if you put up enough quantum of evidence, and this is what I'm talking about availability, the difference between 16 and 32. You put enough evidence in, not repetition. Kahneman acknowledges, and we've heard juries say it over and over and over, that they hate repetition because it bores them. They say things like, well, obviously that lawyer thinks I'm stupid because they think I didn't get it the first 8 times they said it. So they had to say it a 9th time. There's a big difference between repetition and redundancy. Redundancy is what we should do. Redundancy is where you come at the same theme from every different direction. You come at it from the documentary evidence, the demonstrative evidence, lay testimony, and expert testimony. It's all accumulative evidence on the same theme, but just not repetition of the same words, like Fox News, the echo chamber. That's what they're all about. Okay, so the other thing about the unconscious mind is this is the important part of the brain, because this is where processing takes place. I mean, it's where it goes straight through without processing. Is you tell your story in the present tense because the unconscious mind does not process negative. It doesn't process negatives, and it doesn't process things in the future, and it doesn't process things in the past. If you talk about the present or if it's happening in the present, the unconscious mind will process it. So that's why you tell the story as if you are there, and you do it in terms of, all right, let's come back now with me now as we visit this scene. What we see, and you're tell the whole story in that fashion. You avoid negatives. That's why the unconscious mind does not process negatives. That's why you don't say the doctor failed to do this. You say the doctor chose to do this. It's because of unconscious mind communication. Rhetorical devices. What's my time on this? 5 minutes? Okay. Good, I can talk slower. Rhetorical devices, y'all, are extremely important because they communicate directly with the unconscious mind. A metaphor is the power of a metaphor is so hard to overestimate. For this reason, give you an example. The case I told you that I tried in 1971 with the child. This child had digitoxin toxicity, and so which led to heart failure. They had to defibrillate the child 15 times, which means putting the paddles on them and sending an electric shock through the heart until the heart stops beating. Defibrillation. But defibrillation, the word defibrillation fails to, as Aristotle said, execute the required level of emotion. So if you want to know what your metaphors are that will resonate, you do what I did. I had this big discussion with my doctor as we were driving over to Beaumont, actually, for him to testify. I said, okay, we got to think about this. Defibrillation doesn't get there. This was back before we started using focus groups to figure all this out. I said, but describe for me exactly what's happening. He said, well, you put the heart is fibrillating, which just means squirming like a can of worms, and then you put an electric shock through the heart with sufficient force to stop the heart from beating completely. And then the next signal from the brain comes and it starts the heart back to a normal. It's rebooting the heart, basically. And I said, okay, answer this question for me. Defibrillation is just like, and he thought about it for a moment. He said, well, it's just like electrocution. Same thing we do to people in death row, except we keep the thing going until there's no new signal from the brain. So now, I said, you give that metaphor and give that analogy on the stand when you're asked about it by the defense lawyer. At any opportunity. If he asks you your name, say, well, let me explain to you what defibrillation is. So now we're dealing with 15 electrocutions of a 9-month-old child, and that's what drove the damages up so high that it had to be a remediator. I guarantee you that one thing drove the damages so high it got a remediator. Okay, so you want to find metaphors, analogies. Rule of 3 is a rhetorical device. It's a whole long list of things that we use. Okay, so you want to seek similarities between yourself and the jury. It's just like Lisa talked about Oprah. What are they like? Looking at their intake information, what are they like? They all like Oprah, so you like Oprah too. Seek similarities. All right. Sequencing is extremely important with respect to damages. I personally think that you have to, or at least you should, prove your liability first. And then there's a thing called the Zeigarnik effect. You prove your liability first, and then you have to talk about your damages some, but then you let the jury discover on its own the severity of your damages. I never stood up in front of a jury in my life and said on voir dire examination, ladies and gentlemen, this is a medical malpractice case which has caused this poor plaintiff to have permanent, irreversible brain damage. No. You start out by saying, this is a case involving a severe head injury. And then as you move along through the proof, then it gets a little stronger in the language, but only after the doctor takes the stand and answers the question, doctor, is there anything that can be done to cure this? No. how long do you anticipate that? Well, this is irreversible. This is something this patient will live with for the rest of their life. When the doctor says it's irreversible brain damage, now you can say it, but you don't come in and feed them that because it's high. It's the expectations are too high because they may get all kind of images in their mind. So start out with lower expectations, and then the Zeigarnik effect is this. It is that jurors, we all, not just jurors, but we all cling to tenaciously that which we discover on our own. So what we do is we help the jurors discover on their own how severe this injury is. And then once they discover it on their own, it becomes their discovery. Then the confirmation bias kicks into play, which means that they will then begin seeking evidence that confirms their belief. Once they discover that they believe that this is a severe injury, then they'll start looking for evidence that confirms their own belief. And then it really gets good. Availability is, we're back to where we started. This is all about the availability, making available actual evidence of every single element of damage for which you're asking the jury to give you money. I think that's, and then I'll leave you, as I frequently do, with my favorite quote from Shakespeare. The first thing we do, let's kill all the lawyers. Because those of us who actually read the Bard rather than the Cliff Notes in college know that those words are spoken by Dick the Butcher, who was a follower of Jack Cade, who was an anarchist seeking to overthrow the established order in society and put anarchy in its place. So what Shakespeare is saying through Dick the Butcher is, if you want to establish anarchy and do away with the established order in society, the first thing you have to do is kill all the lawyers. So it's truly a great compliment to the bar from Shakespeare. And so he's right. And keep this in mind. Two things you need to think about. One, always maintain your own personal pride of what you do as a lawyer, and maintain the pride of the profession as a whole, what everybody in the profession does as lawyers, because we are, in fact, the frontline defenders of democracy in this country. And as Jerry was pointing out this morning, we're it. So let's so conduct ourselves that 1,000 years from now, the tort reformers and the hard-nosed advocates and the corporations and the Bushes will still be saying, the first thing we do, let's kill all the lawyers. Thank you very much.